Alienation of affection, or sometimes people refer to it as alienation of affections, is somewhat of an oddity, to be honest with you. So is criminal conversation. And it's an oddity because very, very few states in the country still acknowledge it. It is what family law attorneys, plaintiffs' lawyers, may refer to as a heart balm case. And it involves some concepts that some people very much still like, and some people in North Carolina not so much. There are differences between alienation of affections and criminal conversations. And by the way, just internally in our office, we use AACC as the acronym. It's just easier than spitting out a mouthful. But alienation of affection is when someone interferes with your relationship with your spouse, the marital relationship, and damages it. And sometimes that results in ending the marriage, and sometimes it results in counseling and rather extreme expense in getting through that. Criminal conversation, it's not criminal, we still use that term, has to do with having sexual relations outside the marriage. And there are different standards of proof in North Carolina regarding what the offended party, the victim of the interference with the marriage, has to prove in court. So AACC cases are still allowed in North Carolina. In fact, at the time of shooting this video, there was a recent bill in North Carolina General Assembly trying to set it aside, and it failed. And time again, in the courts of North Carolina up to the appellate level and in the legislative branch in the General Assembly up there on Jones Street, it has still been found to be good law in North Carolina. And so no matter how much you like or dislike, as many people don't like, alienation of affection, it's a real consideration. Now, some family law attorneys don't really want to mess with it. It's actually closer to what I refer to as a car wreck case than a traditional separation and divorce, and primarily because it's litigated not in family court. In fact, the majority of them, I don't think it's required to be filed in Superior Court, but the majority of them are filed as a civil pleading, a civil lawsuit in Superior Court, North Carolina. Family court matters, divorce, child custody, things of that nature, are handled by a family court judge in district court. It doesn't really matter the value of the marital estate. And civil lawsuits filed in Superior Court are subject to a jury trial, meaning, put people in a box and they hear your case and decide, first of all, whether there's a cause of action, and secondly, what the damages are. Whereas in a divorce action, a family, traditional family court matter, it's a single judge who serves both as your judge and jury. They tend to be somewhat, like any form of litigation, somewhat expensive to litigate. There isn't insurance, generally speaking. We're not talking about a car wreck where there may be a major carrier involved. And we go through the process of filing a complaint or answering a complaint. We handle both sides of that equation. We sit on either side of the table in the courtroom, depending on where our client's needs are. And we go through answering complaints and interrogatories and requests for admissions and requests for productions of documents and depositions. And then we litigate it going forward. We get a fair number of inquiries about these. Some people don't necessarily understand the law or are surprised to hear that they could be sued or threaten to be sued for alienation of affections. And other people want to enforce the law against someone who they perceive ruined their marriage. There are good reasons to move forward. There are some cases that are quite strong and have merit. There are other times where we just tell people, hey, it may not be worth your time, money, or effort. There are defenses to the cases. I think it's fair to say they're relatively complicated. It's easy to confuse the different terms and what that means. And what may be valuable to you or extremely valuable to you may not come to fruition in a jury trial type of setting. We have to look at these things. So we're more willing to sit down with you, kind of go over things. We do initial consultation. The first thing we do is check, see if we're available for representation. We only take a limited number of these cases on an annual basis. We will take them throughout the Charlotte metro region. We'll occasionally venture out into some of the surrounding districts. And we want to kind of see if we have the time to do it, and secondly, whether or not there's a factual basis, and third, is it worth your while to move forward, or can this case be proven? Criminal conversation tends to be a little bit more difficult to prove, and not to put too fine a point on that, but we'd probably talk about that in the privacy of our office or during a conference, video conference or WebEx or whatever we're using. So give us a ring. Our firm does defend alienation of affections claims, Balm, torts, criminal conversations, and we also presently have a case or two pending. And I'd love to sit down, talk with you, see if we're available and what we can do to help. Hope to hear from you soon.